Welcome to ThePrint. Even though it's been over 14 years since that evening on 26 November 2008 when terror attacks rocked the city of Mumbai, the memories of the attacks still remain etched in the hearts and minds of every Indian citizen. In response, Home Minister P. Chidambaram had at that time announced a horde of measures saying that they were to counter terror, to enhance the security of the country, as well as in a way to assuage the fears that had captured every Indian's minds. One such measure was setting up of the National Investigation Agency, and in fact the NIA Act 2008 was passed with very little opposition this same year in December 2008. The act in fact makes NIA the only truly federal agency in the country, very similar to, if you want to say that, FBI in the US, even more powerful than the CBI. And this is the law that we'll be talking about in today's episode of Laws of the Land. For this episode, you have me, Apoorva Mandhani. We have with us Bhadra, Sinha, and we have with us Supreme Court lawyer Sunil Fernandes. Thank you so much for joining us, Sunil.
Thank you so much for joining us, Sunil.
Thank you.
So, Apoorva has given a brief background on the law, how it came into existence, what triggered it actually. So, can you just explain what NIA is, in the sense, what is the structure of NIA and what is the mandate of NIA?
The introduction is absolutely correct. Before 26/11, before the famous Kasab attacks sponsored by ISI, we never had a pan-India investigative body, because the way our constitutional scheme is, law and order is within the remit of the state governments,
right.
And the central government or the central forces have a very limited role to play. So therefore there was a need to create a pan-India body, because terror was acquiring not only a pan-India color, but it was also operated by handlers who were based outside the boundaries of our country. So it is those unfortunate events of 26/11 got the government thinking about it, and therefore a pan-India national investigative agency which would not be restricted by the state boundaries or by the state governments. So for example, if there is a terror attack in Maharashtra, the center need not go through the Maharashtra government in order to undertake the investigation. If the same terror module or the handlers who committed the terrorist acts in Maharashtra do a similar act in, say, Karnataka or in Uttar Pradesh, you have the police organizations of these states are separate. So many a times you do not have a central database, a central bank, and a common central coordinated strategy to combat all these terror modules and terror organizations which have a pan-India footprint.
Right.
So in order to combat a monster which has a pan-India footprint, you need to have a remedy which is pan-India. And therefore that led to the birth of the National Investigative Agency. Now some people may ask, you already have the CBI, which is also a national investigative body. Central body, then why NIA? Now the problem is that it's like comparing apples and oranges, because CBI's mandate is restricted by its own creation.
Okay.
Because CBI is a pre-independence era statute, a Delhi Special Police Public Establishment Act police, under which it is created, and it is created only for certain specific offences, like say the ones pertaining to public servants under Prevention of Corruption Act, or say economic crimes, or say banking transactions. So CBI's remit is very limited. That's number one crucial difference between CBI and NIA on the other hand. The second critical difference is CBI cannot operate unless there is a consent of the state government.
Right.
So if there is an FIR pertaining to, say, as I gave these examples, to a public servant or banking or economic offences in, say, the state of West Bengal or in the state of Kerala, and those respective governments do not give consent to the CBI, CBI can't enter. Now it's not that it can't, there is still a solution. The Supreme Court has said that the High Courts or the Supreme Court can still order CBI investigation, notwithstanding the lack of consent given by the state government. Therefore you will find a proliferation of matters coming up to the High Courts or to the Supreme Courts, where the prayer is that please hand over this state FIR to the CBI.
Right.
You know, that way. So therefore these are the two major disqualifications, I would say, which CBI suffered from. And they restricted the scope of CBI to combat terror. Now CBI by its very creation was incapable of handling something like the Mumbai terror attacks of 26/11. So therefore a specialized body which would not have either of these two drawbacks. So the DNA of NIA, the initial source of its creation was, number one, it was a specialist counter-terror investigative body. And number two, it does not require the consent of the state government to enter into any case.
So when you say that it does not require the consent of the state government, so are you suggesting that the NIA can suo moto on its own take up any case registered anywhere in the country?
Yes, so now that's is the NIA required to first register an FIR and then it can take up investigation?
So what is the procedure like?
That is in fact the main source of the bone of contention, Bhadra, what you have pointed out in this query. See, under section 6 of the Act, initially, in fact, NIA can initially what happened prior to 2019, there was a massive amendment in the NIA in 2019 and its scope was expanded. But let me just first
let's talk about the
pre-2019. So pre-2019 what happened was that when the Act was created, the Act said that NIA will have jurisdiction to investigate the offences under the schedule of the NIA Act. So that schedule contained around 7-8 of acts, where any offence under that, for example, say unlawful preventive activities or say hijacking of planes, etc., or an incident has 2611, that would come within the remit of the NIA.
So these 7 or 8, just to intervene here, just for a clarification, these 7 to 8 offences are in the context of any terror attack,
totally
right?
Terror.
Or terrorist activity.
Yes, they had no connection with the general plain vanilla IPC offences under the Indian Penal Code. They were specifically tailored to, as I said, NIA's original DNA was a counter-terror body. So it could enter into investigating those offences which had a terrorist angle, and therefore only those statutes which had a terrorist aspect were the subject matter of investigation by the NIA. So this was the pre-2019 position. So then what happened was under section 6, there is a clear mechanism as to how NIA will enter. Initially it says, section 6 starts saying that whenever there is an offence under any of the scheduled acts, those 7-8 scheduled acts, the SHO has to register the offence, inform the state government will inform the central government, and then the central government will take a call whether should NIA get into this or no, based on the material before it. Alternatively, under 6, I think subsection 5, if I am not mistaken, NIA has suo moto powers to enter into any such offence which it feels is covered under any of those scheduled offences. So this is one major, as I said, a shackle which was there with the CBI is not there with the NIA. So NIA can get into it suo moto. It has suo moto powers. And the suo moto powers not only to get into a matter, but the entire subsequent machinery, the judicial machinery is laid out for the NIA under the NIA Act. So therefore, not only can it enter investigation, it can also create special courts in consultation with the Chief Justice of that place. It can appoint public prosecutors, it can conduct the trial, virtually everything. So it's pretty self-sufficient, self-contained.
How did it get past those shackles that were present before 2008? You mentioned that it was under state remit. How does NIA justify this?
No, see, personally what I feel is prior to 2019, as long as NIA's remit was, or the mandate of NIA was counter-terror, I think till that extent there was no problem as such, because terrorist incidents are pretty clear. Bomb blasts and targeted killing of innocents by terrorists to create fear and panic, so on and so forth. So therefore, it's so where NIA is to enter, it was pretty obvious that there is a terrorist incident and NIA has now entered it.
So it was different from just law and order, simple law and order, that is under the state remit.
Correct, as you say, IPC offences. But then in 2019 what happened was there was an expansive amendment in NIA, and the scheduled offences under NIA were expanded to include even Indian Penal Code offences. So therefore, anything pertaining to even it may not be directly connected with terrorism, but if, for example, the Easter bombings in Sri Lanka or the Kandahar attack on our consulate, all those things, the incidents happening outside India were also given the powers to NIA, were given the powers to investigate. Regarding terror, banking, financing, the economic aspects of it, those powers also were given. So the remit of NIA expanded tremendously. Now this is the problem.
So when you, in the sense, it expanded tremendously to all the IPC offences, or only a couple of them?
Couple. But then what happens is, under the NIA Act, if a special court is conducting trial of an NIA related offence, and during the trial there is an IPC offence that crops up, so that will necessarily come to the NIA court and not to the IPC
regular
court,
IPC
which
court
is constituted under the state government's auspices. So now, after 2019, the reason why NIA is so controversial is now there is a turf war. There is a constitutional battle between NIA as a central body and the states who have the primary responsibility under our constitution for law and order. States obviously want to protect their turf, and it is aggravated by the total distrust the opposition states have in the present central government. And NIA, by virtue of its ever expanding powers, it's also open to many allegations and accusations that you are now entering into certain FIRs and cases only to fix opposition leaders. Because earlier, when you had only counter-terrorism as your remit in pre-2019 regime, it was you could not have expanded your reach to quote-unquote politically victimize opposition parties. But now, when your scope has been expanded, the expansive scope is also capable of misuse. And that is the main grievance of various opposition governments, that under the garb of counter-terrorism, what you are actually trying to do is fix political leaders, implicate them in cases, and that is on a political level their argument. And on a constitutional level their argument is that, see, list 2 of our constitution gives law and order has the remit of the state government. You enacted the NIA on a very limited purpose, and now gradually you are expanding the scope. So that's why Chhattisgarh government has moved the Supreme Court challenging the constitution.
That's what I wanted to understand also, probably for the viewers. When you say that law and order is primarily a state subject, then how has this NIA Act been backed constitutionally?
Entry 8, there's another, there's a list 1, entry 8, which says that the government can do these things. So it's the best part about our constitution is that it does gives several free play in the joints. If the government wants to enact something, and the constitutional validity of NIA has been upheld. And on a conceptual level, I would fully support, as my personal view, something like the NIA, because that's the need of the hour. Unless you do not have a national investigative body which can pool in resources and combat threats to our country at a pan-India level, you cannot expect. Now, for example, if Maharashtra police, however competent it might be in trying to combat terrorists across the border, it would have certain limitations. It's territorial limitations. Same would happen with UP, same would happen with Karnataka or Tamil Nadu. So therefore, a national body is required. Now, the problem is this, that when you start expanding its scope, there our federalism comes into question, because our federal structure was such right from 1950 that law and order was the primary responsibility of the state government, and now with the NIA's ever expansive powers, we are in for some very interesting times as to how this is going to play out.
Okay, so okay, fine, we've had a specialized agency to tackle terror cases, and we have actually seen number of high profile cases that are being investigated by the NIA. But a basic problem that has emerged over the years, and that you actually get to realize once you start scrutinizing these cases, is the delay in the trial. Now, what is the reason? If it is such a specialized agency, if it has all the wherewithal to conduct investigation, then what is the main cause for delay? Because I mean, we have gone through data, we have gone through the cases that are pending in the court. These cases have been pending in the court for almost like close to 7 to 8 years, and in most of these cases the trial has not begun. So I mean, if you could just reflect a little bit on that.
This is an problem. It's an endemic problem. It transcends NIA. That's the problem. That
no, but we need to remember that there are special courts under the NIA Act, and those special courts do not hear any other matter except for the NIA cases.
I agree,
right?
Bhadra, you're right on that. And in fact, we have special courts for the CBI, we have special courts for the ED, we have special POSCO courts, special marriage courts, and the conviction rate is abysmal even in those courts. So NIA has not departed from that trend. It's just followed the trend that despite having special courts, the problems in expeditious trials is such that, and to be fair to the NIA, these are matters which are pretty complicated, pretty voluminous record, voluminous chart sheets, documents running into thousands of pages. and then you have several hundred witnesses, and then witnesses may not be at one specific place, maybe all over the country. Some may be absconding, some may be in custody, and so on and so forth. So I would suggest my answer to that would be this problem that NIA is facing. It's unfortunate, shouldn't have happened, because if you have a special act, you have a special court, you have a special judge, you have special prosecutors, and everything is special, yet your conviction rate is so unspecial or so non-special or very pedestrian or very ordinary. That shouldn't have happened, but this is sadly a problem that's across the board we see, and that's the reason why in our country, the process, when you are facing a criminal process, that process is the punishment.
Right.
The punishment is not when you get convicted.
Yeah.
That's a big relief for the accused.
Right.
For them, going through a 10-year, 15-year pre-trial, trial, post-trial process, where bail, trial, meeting lawyers, visiting courtrooms, etc., that takes up a huge chunk of their time, energy, and their waking hours. That process is the punishment.
Right. Sunil, since you mentioned the Chhattisgarh government's petition before the Supreme Court, for our viewers, could you explain what the major contentions are there?
The same, as I said, to post 2019, when the schedules, the offences which were prescribed in the schedule, they were expanded to also include IPC, etc. So, one of the main grounds of challenge is that you cannot do this, because under our constitutional scheme, you have list 1, list 2 and list 3. Right. Various laws are under these 3 broad lists. List 1 is under the exclusive domain of the central government. List 2 exclusive domain of the state government. List 3 are concurrent, where both can enact laws. So they are saying that their argument is that by virtue of this amendment, you have encroached upon the territory prescribed for us by the Constitution of India. So you cannot do that. That is violative of federalism, and federalism has been held to be the basic structure of our constitution. So this is actually unconstitutional. So this is there, and other states also are probably having the same grievance, quite a few states. And that reason for that is also one more very pertinent point I must point out here.
Right.
NIA reports to the Ministry of Home Affairs. You see, so that's another problem with our specialized investigative bodies. They are not totally insulated from political interference. So there is a viable or a plausible argument that there might be some political witch hunt at play.
So Sunil, just to understand another thing, I mean, of course, for the sake of our viewers, is that if a local police undertakes an investigation in any terror attack, and if NIA wants to come in, then what is the role of the local police at that point of time? Does it stop there, or it has, it can assist the NIA? So first question is that, and second is that, are there any special powers bestowed upon the NIA officials under this law?
Correct. So first part of it is, when NIA enters any offence, it has the primacy. It has absolute jurisdiction. Everybody is out, including from the state government. So if the
local police has conducted any investigation,
they have to give it,
everything has to be handed over.
Everything to NIA. Same logic what happens in a CBI case. The police may have investigated it for a few weeks, few months. Once CBI steps in, everything has to be given to the CBI. They have sole exclusive jurisdiction, the NIA. State police have no role in this. But the NIA Act has provisions whereby the NIA can take the help of the local police, can take the help of the state government, and there is a statutory provision. By law, the state governments are obliged to assist the NIA in any area that they seek assistance from. So it's the NIA's call, it's their prerogative. If they want to take assistance from the state governments, they can ask, and if they ask, the state governments are duty bound to assist them. It's a legal obligation under the NIA Act.
Okay. And what are the special powers bestowed on the NIA, the officials of the NIA?
That once they enter, then the entire FIR gets transferred to the NIA.
Okay.
Exclusive investigation, exclusive powers with regards to conducting the trial, and exclusive powers with regards to conducting the appeal, and so on and so forth.
Okay, but search and seizure and those powers remain the...
No, even they also go to, they'll have all the powers. So,
right,
yes.
right.
So, but practically what happens is, you do need the assistance of or liaising with the state government officials, because you can't, it would be too much to expect that those officers would do all the nitty-gritties of investigation. But many a times what happens is that, see, these are very, as I said, the high profile they are, of course, and because they are high profile, the investigation into this is also multi-layered. So unlike a plain vanilla offence under an IPC, for example, a fight or a murder, which are localized, which have localized players and which have a localized incidence. This would have a pan-India or a multi-state or even an extraterritorial angle in it. So therefore, you have NIA for that purpose is extraterritorial. They will be liaising with other departments of the government.
Right.
And with regards to the local nitty-gritties, of course, they would take local help from the state.
So when we talk about special courts, what is like the jurisdiction issue? When
So special courts, Bhadra, would mean that all the offences which NIA has the right to prosecute, they would all be held in under one single roof. The NIA Act itself enables the NIA to request the Chief Justice of a specific High Court. For example, if there is a terror attack, say in Madhya Pradesh, so the NIA Act authorizes the NIA to request the Chief Justice of the Madhya Pradesh High Court to assign one of the Court of Sessions, one of the Sessions judges, as a special judge for NIA cases. So the Chief Justice will then issue a notification saying that Mr. So-and-so judge of so-and-so area is designated as a special court for NIA offences. So that FIR which NIA registers will then be prosecuted in that specific court. The trial will be held in that specific court, bail, pre-trial, post-trial, everything happens in that specific court.
Right.
Okay. But in the sense that the special court is going to be constituted in that particular state where the alleged offence takes place,
Yes.
or does NIA or can NIA actually take it out of that state also? Is that possible?
For example, under the Act itself, if there are certain extraterritorial operations, like for example, if an offence has been committed outside India, or there is an incidence of a part of the offence being held outside India, then New Delhi has jurisdiction.
Yeah, because the reason why I'm asking you is because there are some terror funding cases related to J&K which are being investigated by NIA, but the trial is pending in Delhi.
Correct. Because those funding have happened across the border.
Right.
Okay.
So it has an extraterritorial operation, therefore Delhi would have jurisdiction.
Okay. So, let's, there was a purpose and an objective behind the NIA Act when it was, promulgated and the specialized agency was created. So, how do you rate the journey so far? I mean, of course, apart from it being a very controversial agency now, how do you otherwise see the journey so far of NIA?
Also, just to add to that, do you think there are enough checks and balances at this point within the agency?
She had already asked me a very loaded question. I would have, could have made
just final question for our viewers.
I wouldn't. My candid answer is this government is not the first government to have tweaked or used or abused its powers to settle political scores. Let's not kid ourselves. There have been government before this also who have done that. So probably it's being done at a very more fine-tuned and a more precise manner. But at the end of the day, see, this is one of our core problems of our federalism: the utter lack of trust between the center and the federating units. Now, as long as the federating units or the state governments are of the same political color what is there with the center, you will certainly find NIA, CBI, ED absent from those states. As if, crimes which are in the remit of CBI, NIA, ED are totally absent, in those states. But you will find that states ruled by opposition parties, there would be a tremendous spurt in the cases registered by the CBI, ED, NIA, and so on and so forth. You look at how active ED is in Chhattisgarh, in West Bengal, in Kerala, in Maharashtra before Eknath Shinde, and see how active they are in states like say Uttar Pradesh or say Gujarat. You never hear anything in the newspapers about the ED or the NIA or the CBI looking into anything with regards to these state governments. So there is some, if there is a fire, there is a smoke, there is some fire somewhere. So I think this calls for mature statesmanship both at the central and the state level. The state level leaders should realize that the NIA is the need of the hour.
Right.
Because unless and until you don't have a body like NIA, we'll be always susceptible to attacks from our not so friendly neighbors that we have. And at the center should show a greater political statesmanship and not, and resist the temptation of, having this immense power, to fix certain political opponents. I think if both of them perform in conformity to their constitutional obligations, I think NIA should do a far better job than it has done up till now.
Okay, on that note, we've reached the end of this episode. We began this episode by talking about why NIA was set up. As Sunil said, it was set up to be a pan-India body to deal with a pan-India monster. Things have changed since the 2019 amendment, the validity of which is yet to be tested by the Supreme Court. We'll keep an eye on that. Till then, thank you so much for watching this episode. Do let us know in the comment section what you think about this episode. If you have any other suggestions for laws that you'd like us to take up and discuss on this show, do not hesitate to tell us about those laws as well. Thank you so much for watching.